Any mention?
Please, Lordship. I'd like to mention item number 7, Lordship. Pray for 2 weeks' time, Lordship. Again.
Yes.
Pray for 2 weeks' time, Lordship.
My lord, I have no objection.
2 weeks on the request of biggest petition.
Obliged.
Yes.
May I please, Your Lordship? I beg to mention item number 5, my lord.
Yes.
My lord, I am seeking for 2 weeks time, my lord.
Same or 2 weeks. Yes.
Highly obliged, my lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 6. Appearing for respondent number 2, Your Lordship. I pray for 2 weeks' time.
No objection, Your Lordship.
2 weeks on the prayer. We don't know the respondent. Yes.
Much obliged.
Yes.
Item number 1.
Please, Lordship.
Yes.
Mr. Khera will be coming, Lordship.
Yes. Done.
Yes.
Yes. What is the case, Mr.
If Your Lordship recollect, that is regarding the maintainability of civil revision against a review application.
What is the factual background? Just can you, the court has forgotten it, in fact.
My lord. My lord, here the
There is that landlord tenant.
landlord tenant.
Just can you give us
Landlord tenant. My lord. My lord, what happened, my lord, in the first trial court, it's an eviction suit. So in the first trial court, my lord, it was the eviction suit was dismissed and it was in favor of the tenant. Now, thereafter, they went on first appeal. And in the first appeal, it has been reversed. Now, my lord, against that order of the judgment of the first appeal, my lord, first appeal, the decree was granted, my lord.
review was filed. There.
Review was filed. So, against, in that review, my lord, there was an application for bringing in some additional evidence. So, the review petition was rejected. Against that, we have come before Your Lordship on a revision. Now, my lord, my friend has argued on the point of
Maintainability.
my lord. And they have relied on one judgment, which was placed before Your Lordship.
Mr. Khera. Yes, Mr. Kharkhan.
He's coming, Lordship.
His coming means if it is an issue of maintainability, he should be here.
Lordship.
My lord.
We had already placed the point of law, Lordship, is only for
So, so far as your thing is, it's over. So far as your plea of maintainability.
Lordship. Service of
Yes.
My lord, my lord. So, my lord, they have relied on one judgment, my lord,
Yes.
that is of 2024,
Yes.
Rahimal Bathu and others versus Ashial BV, my lord. Now, in this, my lord, there is a finding, my lord, that the revision against review will not lie, against the rejection of review. Now, my lord, so my endeavor now will be to take Your Lordship through this judgment, my lord. And
You said this is par incurium and doctrine of sub-silence you will apply.
all that, my lord. That basically, because the aspects relevant.
Par incurium,
My
then
lord.
what has been not been taken into consideration in this judgment?
My lord, my lord. That is what.
If, there are two aspects. Now the court remembers. You see,
my lord.
you raised two pleas.
My lord.
Basically, one is that that is a judgment in par incurium,
My lord.
and second that the doctrine of sub-silence you will apply.
My lord. That is what.
Okay. Now, so far as the par incurium is concerned, there is a distinction between par incurium and sub-silence.
Sub-silence.
Now, if your plea of par incurium, if you say that something has not been taken into consideration when this judgment was taken,
My lord.
what is that? What part of
I'll take your Lordship through the judgment, my lord. And in view of the facts of our case, my lord, my endeavour will be to satisfy your lordship that this judgment, my lord, is silent on the sub silentio will come, my lord.
So sub silentio will be more applicable rather than,
more applicable
Yes.
than par inquiry, my lord.
because fact of situation of your case is something different.
Something
That has not been taken into consideration.
right. That is my effort, my lord.
Yes.
This is that one, no?
So your plea is of sub silentio.
Primarily, my lord.
Yes, please.
So, my lord, first of all, I'll take your lordship to para 8 of the judgment, my lord. What was the crux of the issue in this judgment, my lord?
Yes.
Well, the High Court entertained the revision, and by the impugned judgment and order dated 12/9/2017 allowed it. The High Court not only set aside the order of the trial court rejecting the IA number so and so, but it also allowed the review application and modified the decree dated so and so in terms prayed for in the review application. In consequence, the decree of the trial court, which was in respect of 1/6 share only of the second schedule property, was extended to the whole of it and the operative portion of the judgment. So, my lord, here, firstly, my lord,
Please go ahead. Yes.
my lord, the review application was in the trial court only, trial court itself, not in the first appellate court. It was in the trial court itself. And against that review application, my lord, the matter went up to the High Court. And what the High Court did, my lord, High Court allowed the review application. This has a bearing, my lord, on the it allowed the review application.
It has
and
not only allowed the review application,
it
it modified the decree.
Modified the decree. My lord, that is
That is basically you can say exercise of jurisdiction, excess of exercise of jurisdiction based on it. So far as the issue before the High Court was concerned.
my lord. So my lord, what happens here? Anyway, we'll come to that, my lord. What happens here, my lord? The decree becomes a decree of the High Court. Here in this case, my lord. Now, my lord, para 11, if I can take your lordship.
Yes.
So, the contentions of the appellants, my lord. Number one is that the High Court exceeded the jurisdiction by entertaining the revision against an order which declined review in an appealable decree. My lord, it was an appealable decree. Against that, review was allowed, and the High Court finally gave the judgment and decree, my lord. Now, number two, my lord, assuming that the revision was maintainable, the High Court could not on its own modify the trial court's decree, which was not the subject matter of challenge before the High Court, my lord. Now, if the trial court, then number three, my lord, if the trial court had committed any jurisdictional error in rejecting the review application, the High Court should have remitted the matter back to the trial court for a fresh consideration of the review application. It should have remitted back to the
That is
court.
what the correct position of law is, so far as simple understanding is concerned.
My lord. That is the thing. That is what was not done here, my lord. Now, number four, my lord, if the High Court's order is allowed to stand, the defendant's right of an appeal under Section 96 CPC, first appeal, would get affected as the trial court's decree would get merged in the decree modified by the High Court. This point is very relevant. Milord. So this is the situation which was obtained in that particular case, Milord. Now, Milord, I'll take your lordship straight to paragraph number 28. Twenty-eight, Milord.
Yes.
The short question which arises for our consideration in this appeal is whether a revision under section 115 CPC is maintainable against an order of the subordinate court rejecting on merits an application for review of an appealable decree passed in a civil suit. So, Milord, Milord, the review application, by rejecting the review application, Milord, what we will find as we go through the judgment, Milord, is the view of the Honorable Supreme Court here is that when the review application was rejected, then the revision applicant here, that means the review applicant also, Milord, he had the alternative of going on appeal against the decree. His right to appeal was not.
No, but then here you also have the same.
That is what
That right is, if that is the basis, then you also have the same right.
that is one basis, Milord. That is one.
In that case, it was section 96. In your case, it will be section 100.
Milord, I'll come to that, Milord. I'll come to that. Why on that, Milord, I would be submitting that the judgment is silent. Judgment is silent, Milord, on that aspect. So, Milord, this is the question which was before the Honorable Supreme Court, and the Honorable Supreme Court decided on this point, Milord, as reflected in para 28. Now, Milord, in para 31 and 32, this S.S. Khanna's case has been discussed in details, Milord, and the provisions of review and all that has been discussed. Now, Milord, para 33, if I can take your lordship.
Yes.
Para 33. The law laid down in S.S. Khanna by a three-judge bench of this court still holds the field. Thus, it is settled that the expression case used in section 115 CPC is of wide amplitude. It includes civil proceedings other than suits and is not restricted to the entirety of the proceeding in a civil court. In that sense, rejection of a review application would also be a case which has been decided, and therefore it could be canvassed that as no appeal lies against such an order, the same is amenable to the revisional jurisdiction under section 115 CPC, revisional jurisdiction. Now, 34 also, Milord, I will just take your lordship through. However, at the same time, it cannot be overlooked that exercise of revisional powers cannot be claimed as of right. It is a discretionary power. The revisional court is not bound to interfere merely because any of the three conditions as laid down in section 115 CPC for exercise of such power is satisfied. Rather, the court exercising revisional powers must bear in mind inter alia whether it would be appropriate to exercise such power considering the interlocutory character of the order, the existence of another remedy to an aggrieved party by way of an appeal. So this is Milord, our
Becomes a discretionary power. Discretionary power. That is what.
discussion.
One and
Discussion.
That is, these are settled. See, there cannot be any dispute with regard to that.
Right. So, Milord, from the ultimate order or decree in the proceeding or by a suit and the general equities of the case. Now, Milord, para 35. Now, my lord, para 35 deals with that appealable decree, that aspect, my lord. Now, in SS Khanna, the order impugned before the revisional court was an order by which the trial court, while deciding a preliminary issue, held the suit as not maintainable, though the suit itself was not decided. Therefore, there was no appealable decree in existence at the time when the revisional jurisdiction was invoked. Whereas in the case at hand, there was already an appealable decree in existence when the revisional powers were invoked. In fact, the review application sought review of an appealable decree and not just a mere order that might have been passed by the court in the course of a suit. The revision was filed against rejection of that review application. At that stage, when the review application was rejected, the aggrieved party had a right to question the decree of the trial court in an appeal. In these circumstances, the question that needs determination is whether, against an order of the subordinate court rejecting on merits an application for review of an appealable decree, a revision be entertained. So here, my lord, in my humble submission, my lord, the Honorable Supreme Court did not take into consideration the scope of second appeal.
But then the fact remains that review is a discretionary jurisdiction. Now, this court may
Revision.
even, you see, like even if you invoke that doctrine of sub silentio, court may still say that is a discretionary remedy and you have a remedy available. You can-
Yes, ma'am.
So what do you do in such a situation?
So, my lord, I will try to satisfy your lordship, my lord. The remedy which is envisaged here, the availability of remedy, that in my case is not there. In a second appeal, my lord, because in my lord, my whole case before your lordship is that the first appellate court had the powers and the jurisdiction to take evidence. And in that second appeal, my lord, that is not available to me, my lord. So, my lord, what happens in that situation, the limited scope of second appeal, on that, my lord, this judgment is silent. This is the first aspect.
Now
my
you are
lord.
trying to make a further distinction between a first appeal and second appeal. Now you are trying to contend that the first appellate court, probably the last occasion you have raised that plea, that the first appellate's power, it's the appellate court's power to record additional evidence.
Right.
Now,
Order
that is what
21
you
Rule
have
47.
Now the fact remains that you did not file any application under Order 41 Rule 27 when the appeal was pending.
We filed it when the review was filed.
Okay. So
one-
far as when
one
the
day.
appeal was pending, you did not file any appeal.
No, we filed it when the review was filed.
So when that was not done,
my lord.
which way we can say, because the review stood rejected. Now, what are the situation in the review will not be taken into consideration.
Because, my lord, in that review, my lord, that was the main point. That, my lord, because additional evidence has come to light and that is required to be brought before the Honorable First Appellate Court. So, on this,
Then you have to show us that which way exercise of jurisdiction by the court in rejecting the review application is wrong in law. It is a revision application. We will confine to the jurisdictional area.
jurisdictional. My lord, if you're first, my lord, on the maintainability part, my lord, on the basis of this, and that may not.
But then your argument on maintainability may be to some extent dependent on that.
Yes. It is dependable to a large extent, my lord. So, my lord, I'll just complete this, my lord. What is the ratio laid down in this judgment, my lord? Now, my lord, if your lordship comes to para 38, my lord,
Yes.
37, 38, my lord.
Yes. Okay.
37, 38. What is clear from the above observations is that where the review is allowed and the decree order under review is reversed or modified, such an order shall then be a composite order whereby the court not only vacates the earlier decree or order, but simultaneous with such vacation of the earlier decree or order, passes another decree or order or modifies the one made earlier. The decree so vacated, reversed, or modified is then the decree that is effective for the purposes of further appeal, if any, maintainable under law. So, here, my lord, if the review application was allowed, and then that would be the decree, my lord, and then
Is it? Mere granting a, if you are granted a review, would it mean that review will be this thing?
no, mere granting, no, by after granting the review,
But then here, your case, so far as your case is concerned, you have coming is rejection only.
rejection.
Had it been allowed also, it would not have meant that the decree would have modified, would stood more modified.
After allowing, my lord, that the decree would be would have to be reconsidered.
That would basically amount to something like giving you granting you opportunity to rehear.
Right, my lord. Right. That is what, my lord. So, my lord, the matter, in any event, my lord, in my case, my lord, the matter travels back to the first appellate court. That is the second point, my lord. The first is on that second appeal, distinction between first scope of first appeal and second appeal. That has not been discussed. And what happens if the matter travels back to the court which granted the decree? That also has not been discussed here, my lord. So, my lord, para 38, but where the review petition is dismissed, on this dismissal, my lord, para 38, there is no question of any merger, and anyone aggrieved by the decree or order of the tribunal or court shall have to challenge within the time stipulated by law the original decree and not the order dismissing the review petition. Time taken by a party in diligently pursuing the remedy by way of review may in appropriate cases be
You are
excluded.
not concerned with those part. Condonation of delay and all, you are not concerned with.
I mean, here they are saying that time spent for review application, that may be condoned, and against the original decree, appeal might go, my lord. So here, my lord, again I am hit by the fact that in the second appeal, I would not have the scope.
You can avail that. Say supposing in the event your present revision application gets rejected,
My lord.
definitely this will be taken as
No, my lord, but on the question of facts, that additional evidence and all that, the limitations of second appeal, my lord, that is not discussed.
additional. The fact remains that there was no prayer by you before the appellate court during the pendency of the appeal to record additional evidence. You have raised such plea only at the review.
Review, my lord. Review.
Now that is where the problem is. Now whether consideration of review
My lord.
by the appellate court would amount exercise of appellate jurisdiction, because the fact remains the time when review application was considered by the court, there was no appeal alive.
There was no appeal alive.
Yes.
There was no appeal alive. Yes, my lord.
So that is where.
My lord. So, my lord,
Still,
here,
do you want to say the exercise of review jurisdiction by the appellate court would still be considered as exercise of appellate jurisdiction?
review application by the same court, my lord.
By the appellate court, yes, by the same court.
Same, first appellate court.
Here it is appellate court.
First appellate
Okay.
court. First
Now,
appellate court.
appellate court exercises appellate jurisdiction
Malad.
when it considers the appeal remains under consideration.
My lord.
Now, once appeal is disposed of
My lord.
and a review is filed,
Malad.
whether appellate court again assumes appellate jurisdiction or it merely exercises review jurisdiction.
My lord, its jurisdiction is appellate only, in my humble submission, my lord. Its jurisdiction is appellate only, my lord. In the appellate,
Just merely because the fact that the appellate court is exercising review jurisdiction, will it mean review jurisdiction will get converted into appellate jurisdiction? Say supposing for exercise of review application by a trial court or maybe a court of first instance, there will be no scope for any way timing it as an appellate court, the appellate jurisdiction, isn't it?
the whole jurisdiction of the court, my lord, the whole jurisdiction of the court is essentially first appellate jurisdiction, in my humble submission. First appellate jurisdiction. So, it is a review of the, within the parameters of the first appellate jurisdiction.
Do you have anything to show the court that even when court considers
Malay.
review application,
Well,
it basically exercises the same jurisdiction
same.
which is vested.
Of course, if we find something,
That is something. Okay, what you say, that is where probably some clarification will be needed.
so Milord,
Because for entertainment of your application under Order 41 Rule 27, court must exercise appellate jurisdiction.
my lord, well.
Now, if in a review application,
So what
It
the review jurisdiction cannot be separate from the original jurisdiction of the court. The original jurisdiction of the court is an appellate jurisdiction, undoubtedly.
may not be very much correct. See, so long appeal is under consideration, court exercises appellate jurisdiction. But the review is something, it is totally review. No other jurisdiction cannot be clubbed with it. Review application filed before any court, say like a order of a court of first instance, you file a review application. This court exercises review jurisdiction.
So,
Okay. Can we say that this is exercising original jurisdiction while considering the review application?
in my humble submission, what I understand is that the jurisdiction itself of the court, it is within the jurisdiction of the court itself that the review application has been filed. Within the jurisdiction. And that jurisdiction is only one jurisdiction. That is in the trial court it will be the original jurisdiction, in the first appellate court it will be the first appellate jurisdiction. So the review...
Give us something, if you say that.
Miller. So on this point, Miller, this judgment is silent.
What you say, that is definitely, it has certain basis.
Miller.
So far as your main thrust, that additional evidence, there will be no opportunity for you to file such application before the second appellate.
Second appellate court. That question cannot be urged.
The opportunity which you are basically trying to grab or trying to avail would not be available for the second. It
So
will not
that
be-
distinction between the first appellate jurisdiction and second appellate jurisdiction.
And second thing is that the situation under which this present judgment was passed, where the High Court had not only allowed the review, it modified the decree.
My lord, that is the second part.
Basically, the assumption of jurisdiction of the appellate court by the High Court in a revolutionary jurisdiction.
My lord,
That was the case in that case.
my lord.
In that
Case. But in
but
our
here it is not. Here
it will not be that. Yeah, on that also, the various aspects which might arise, the various possibilities, that has been discussed, but this aspect, this possibility has not been discussed in this judgment.
But
In this
again, something else has been said here. Here it has been said in maybe, you see, rather it's very direct way also. It says that if a rejection of review in a matter where the order in question is appealable, no revision would apply.
Yeah, that is what it says, but the whole case arises out of first appellate of the trial court, my lord, and the jurisdiction being considered by the Honorable Supreme Court here, my lord, was only the jurisdiction of the first appellate court. So in the first appellate court, because there is an alternative remedy by way of appeal against the decree, my lord, now that remedy in my case is not available because it's a second appeal. And my lord, what would be the situation in a second appeal?
You know, what opportunity you said it? Just say it again. The submission which you give just now. The alternative remedy means?
That means, my lord, here the whole thrust is that, my lord, the revisional jurisdiction cannot be entertained because there is a scope of going on appeal against the original decree. But in my case, my lord, the point on which the review has been sought, my lord, that is essentially a factual point, my lord, question of
Okay,
fact.
but then see, otherwise, fact remains that is also a decree.
Appellable only on law points.
Okay, appealable, but then your case, it is only second appeal.
Second appeal.
Here it is first appeal.
First appeal.
That
And
is
that distinction
Yes.
between first appeal and second appeal jurisdictions, my lord, that has not been discussed in this case, my lord. That is the thing, my lord. Now, my lord, 30, I was 37. Now 38.
You have read 38. You are reading,
30,
actually
38
partly, you are
we have
partly reading that part about this condonation part.
My lord, that was in
Time taking by a party.
that was in 38 minutes. 38. Now, my lord, 39 minutes.
Yes.
39 is very relevant, my lord.
Yes. Please.
Apart from the above, there is another reason also for a revisional court not to entertain a revision against an order rejecting on merits an application for review of an appealable decree, which is if the revisional court sets aside or modifies or alters the trial court's decree, the decree of the trial court would merge in the one passed by the revisional court.
This is not the case here. There is no question also.
So
Even this court allows your petition, that will not be an interference with the decree.
so
Only the mere direction can be passed, remanding it back to the appellate.
and that is the prayer also.
Reconsider.
That is the prayer, my lord. So, my lord, my respectful submission, this possibility of the matter being remanded back to the court against whose order we have come, my lord, on this is absolutely silent. This judgment has not discussed that aspect at all before coming to the final view. On the, my lord, my lord, here it says that when the divisional court gives a final order, my lord, on the merits of the case, then that is what it says. I'm just putting in a nutshell, my lord, that the order of the court below becomes merged with the order of the.
Where is the scope of revisional court interfering with the decree? Which law permits it?
So here
The moment court does it, that will be an illegality. Just tell us.
So that is what was done in this case, my lord. That is what was done in this case, and that is why, my lord, because what happened, my lord, when the order of the trial court below was merged with the order of the High Court, so the parties lose a.
That is, you have already said it. That was in that case, High Court not only allowed the review of plea application, it has modified the decree.
My lord, my lord.
This is what the case is here.
And my lord, in my case, my specific prayer is not for a decree. My specific prayer is to remand the matter back to
So the proposition laid down in this decision will not be applicable in the case.
my lord. It is silent. It is silent.
Situation
Totally
your
different.
case has not been considered.
Not been considered, not
The
been
judgment
discussed.
is entirely silent on that aspect.
On that aspect. So these are the two areas on which this
Your entire is on the doctrine of subsilentia.
subsilence.
Par inquiry is not coming.
Par inquiry. Subsilence. It is on subsilence. So, my lord, on the basis, this is the ratio.
Okay, that is so far as your answer is maintainability is concerned.
Maintain.
You want to say something, anything more on maintainability?
My lord, in 42, when the Honorable Supreme Court finally says
Yes.
that revision is not applicable on review, this is on the basis of this ratio. The ratio which has been discussed all through, my lord.
For all the reasons above.
All that is
That is means which has been recorded in the judgment.
recorded in the
And that your reasons is not included in this reasons.
Right. That is my case. So this honorable judgment, my lord, would not directly apply to. This is on the maintainability. My lord. This is on the maintainability.
Yes, Mr. Khera, you will say anything on maintainability, but then you have to satisfy the court on other aspects.
On the main.
That we may say this thing, but in so far as your merit of a revision is concerned, the exercise of judicial.
That I love.
Yes, what you will say on maintainability?
My lord, this petition is not maintainable as I have been arguing from day one. Now, my lord, we have stopped in the judgment at para 38, para 39.
Yes.
My lord, we go beyond that. At para 41,
Yes.
in the instant case, the trial court which had jurisdiction to allow or dismiss the review application, dismiss the review application on merits. Now, my lord, we will have to see the impugned order here. This is a revision. We'll have to see if the impugned order suffers from any deficient on exercise of jurisdiction. whether the court went overboard to exercise or under. Now, my lord, to understand that, we will have to come and see Order 47.
No, that's
Order
okay.
41, Rule
We
27. No,
that is
it's
we
on
can understand.
maintainability,
See,
my
what you
lord.
are trying to say, that will have a bearing on the merit of the case when Mr. Chakraborty argues it.
My lord,
Okay, about exercise of jurisdiction by the court.
my lord,
But then so far as the maintainability, see, probably you have followed what Mr. Chakraborty
My
said, or you can,
my lord.
you were not here the initial part. Mr. Chakraborty has distinguished his judgment,
My lord.
saying that the fact that situation involved in the present case, okay, that was never been discussed in the judgment by the apex court.
My lord,
And in that matter, what had happened, High Court, while allowing the revision application,
Well-
not only allowed the review, but also passed a decree, modified the decree. Here it is not at all a case. He is not seeking any interference with the decree here before this court. His only prayer is that this review, he should be granted review and saw that decree should be, the matter should be heard again.
my lord. My lord, now the question is that we'll have to, if we see the ratio in this judgment, my lord, to understand the ratio, we will have to go and read para 41. Because the court says, why should the revisional jurisdiction not be exercised
Yes, yes.
against an order rejecting a review of a decree which is appealable? Because my rights will be adversely affected, my lord.
Please,
May I?
take us.
In the instant case, the trial court which had jurisdiction to allow or dismiss the review application, dismissed the review application on merits. If it had granted the review, the aggrieved party would have had a right to file an appeal under Order 43 Rule 1 W, read with Order 47 Rule 7 CPC. And if it had allowed the review and simultaneously altered, modified, reversed the decree, then the aggrieved party would have had a right to file an appeal against the said decree. But if the revisional court does the same as has been done by the High Court while passing the impugned order, an anomalous situation would arise. The decree passed in the trial court would stand modified by the High Court. Therefore, if the defendants against whom the decree is passed were to challenge the same, they would be at a disadvantage on account of the merger.
Wait. 1 minute. That means,
My lord.
just for the court's understanding. Now, if the review had been allowed, then you would have had a chance to file an appeal under Order 43 Rule 1,
My lord.
isn't it?
My lord.
Now, say supposing if the revisional court at this stage
My lord.
interferes and allows the review, then your right under Order 43 Rule 1W will get defeated.
That's what the
So
interpretation.
that is the basis why this revision should not be entertained.
My lord, that is the very basis. Because their court says, if your decree is appealable, you go for an appeal.
Is it correct? What the court has understood or not?
My lord.
No.
My lord, can we proceed ahead?
See, just a minute. If it had granted the review, the aggrieved party would have had a right to file an appeal under Order 43 Rule 1W.
My lord.
That means it's speaking about you. If the review application was in his favor,
There is a possibility I would have been agreed.
before the court could have proceeded to alter or modify the decree,
My lord.
you would have an opportunity to file an appeal under Order 43 Rule,
My lord.
isn't it?
My lord. But if the revision does it, I will lose that opportunity, my lord. And my lord, the para ahead, my lord, just one para. It says,
Yes.
whereas from the standpoint of the respondent plaintiff, even if we assume that the trials court decree is inconsistent with its finding on the validity of the gift in favor of so and so, she can challenge the same in an appeal against the decree even after rejection of the review application. In the event of such an appeal by the plaintiff, the defendants, even if they had themselves not filed an appeal against the trial court's decree, would have a right to take objection to the adverse findings under Order 41 Rule 22 CPC. However, if the revisional court's order is allowed to stand owing to modification of the decree by the revisional court, to which in normal course an appeal would lie, the right of an appeal to the aggrieved party would get seriously
No,
prejudiced.
that is owing to modification. See,
My lord,
we are not modifying decree here.
My lord.
Even if we grant his prayer now,
my lord,
we are not going to modify the decree here. At the best, matter will go back to the first appellate court.
my lord.
When first appellate court will be directed, reconsidered his plea, and on that basis, if required, you modify or alter decree. Now, say supposing if decree is left untouched, then there will be no grievance on your part. But then if it is touched, then you can also challenge it again.
My lord. My lord, but the question now takes birth is, assuming if the court, my lord, directs the lower court to reconsider it, then we will have to see if the lower court.
Now, so far as this court is concerned, it is more concerned with your right under Order 43 Rule 1.
My lord,
Now, that is what?
my lord.
Which way we deal with it?
Order 43, Rule 27, my lord.
The Order 43 Rule 1 W.
My lord.
I do not know. That is something problematic. If review is allowed, appeal lies. Is it? And if review is rejected, against rejection, no appeal lies. That is what the
My lord.
proposition of law.
My lord. So now, even if they have an issue with law, they can go under Section 100, my lord. If the court below is erred. But then the court below has applied its mind, has come to a conclusion that in view of Order 41, Rule 27, my lord, which was the opportunity when they could have filed an application, when the court was sitting as an appellate court. They did not do it, and thus the court says at the stage of revision, I cannot exercise this power. They had ample, court also goes on to record the findings, my lord. They had ample opportunity. Right from the time
Whether
of
they
trial.
could have filed an application in that review application.
They could not.
Telling.
They could not.
Is there-
And even in the
do you
review,
have a law on that?
my lord, even in the review application,
You have a law on that. If you have, just show it us. Let us say. If you have a.
my lord, the provision itself says.
Yes. What is it? No, that is okay. That's provision. What provision says, we have seen it.
And my lord, when the court is sitting as
If
an.
you say you have something, say, Mr. Khera, be fair in your thing.
My lord,
See, ultimately we are trying to come to a correct conclusion.
my lord.
Okay. Now, if you say that you have a decision on that and all, you just say it is there. If it is not there, it is not there.
My lord,
Okay.
the law, the legislation itself is clear, amply clear. The words, when it categorically says when can it be done, and same thing is what the lower court has, the appellate
But
court.
that is okay. But then the moment we go and answer that question, touch that question, whether it could have done or not,
My lord,
probably we will be deciding on the merits of his application.
my lord,
Now, so far as the maintainability is concerned.
and my
The
lord,
plea that yes, order passed.
they never filed an application under Order 41, Rule 27 also. They never filed it. They merely filed a simple application saying at the review stage to allow us to adduce some evidence. But still the court goes ahead, interpreting it as an application filed under Order 41, Rule 27, and then decides it's on merit.
That is all. Acha, the court has decided that also on merit.
Yes, my lord.
This rejection of application was on merit,
My lord.
not on the ground that this cannot be, such application cannot be filed in review.
No, my lord. The court went a step ahead. They did not file it under Order 41, Rule 27.
So that way they should not have any grievance about non-consideration of their
My lord,
application.
page 63 is the starting of the judgment, the impugned order, and it culminates at page 79. If, my lord, we can only visit page 79, the last paragraph, if I may, my lord.
Consideration of merit
My lord,
of
the circumstances and ground taken by the petitioner.
Allow the court to come to the court. Why you are in so much hurry?
My lord,
You have some hearing somewhere else.
no,
You are reading page
my lord, page 70, the last page of the petition.
of their petition. Page 79.
My lord,
Yes, please. Yes, please read.
in fact, my lord, if we can come from page 70. My lord, we can visit page 79, para 25. And
This is order by which court?
the court of the learned session judge, district judge, my lord.
Here in Shillong.
Shalom. District judge.
Page.
Page 79, the last page of their.
Oh, yes, we were in page 79. Then again, you wanted to change. Then okay. Yes.
My lord, it's page 79 in my judgment.
Yes. Paragraph. Which
Para
paragraph?
25, my lord.
Yes, read it.
The circumstances and ground taken by the petitioner contemplates reappreciation of evidence which is not permissible in review
That
application.
is what it says.
Yes.
So that is no. It's okay in review application. Now the question comes that the consideration which could have been granted at the stage of consideration of appeal,
My lord.
whether court can give the same consideration to application filed in review jurisdiction or not.
No, my lord. And my lord,
The
we'll see.
question is that, but then again we are going to this thing. See, just let us first on, see, moment we come to that question,
My lord.
that will relate to the exercise of jurisdiction by the court concerned.
My lord.
Okay. Now, so far as the maintainability of this revision application is concerned,
My lord.
on the plea which you say that the order of the first appellate court is otherwise applicable under section 100.
My lord.
So by following the proposition of law laid down by the appeals court, no revision will be maintainable.
Not.
That is what you are saying.
Yes, my lord.
Now Mr. Chakraborty has made a distinction on that. He said that the fact and situation which was involved in the decision of the appeals court which you have relied upon, that is not there.
My lord,
Plus,
with all due
the
respect.
other aspects about the first appeal and second appeal, that also was not considered by the appeals court.
It was not.
And the reasoning given totally on the basis of the facts which were before the appeals courts.
My lord.
So definitely, so far as his case, facts of his case is concerned, the doctrine of subsilentia will apply. Now tell us, when can we apply doctrine of subsilentia and when we cannot?
My lord, the judgment in question very categorically states, when it lays down the ratio, it's saying any decree which is appealable, if a review in that has been rejected,
We have seen that words.
court
But then,
should not or could the court there could not have used its revisional jurisdiction and gives a reasoning for it. Now, my lord, if we have to put that ratio, we'll have to see if this revisional jurisdiction is exercised and it goes on to eventually alter the judgment or affect the existing judgment. How does it hamper my right? If we have to see the ratio, we'll have to see it on both the ends, my lord.
anyway, we'll do one thing, Mr. Chakraborty, you argue on merits also. We'll just see, we'll take it all on. It is useless deciding the matter on piecemeal. You can just say about now you question the.
My lord, page 9 is their prayer. We will have to see what is the nature of relief that they are
Before
seeking.
this court.
My lord. Page 9, my lord. May I?
Yes.
In the premises aforesaid, the humble petitioner above named most respectfully prays that your lordships may be graciously pleased to admit this petition, call for the records from the honourable court below, issue a rule calling upon the respondent to show cause as to why the said impugned judgment dated so and so in the review petition number so and so of the honourable court of the district judge Shillong shall not be set aside and quashed, with directions for deciding and answering all the grounds taken in the review application, and also for allowing the adducing of additional evidence as has been prayed for by the petitioner.
Yes.
So, my lord, they are coming before your lordship saying that the lower court to be directed, I believe the first appellate court to be directed, my lord, to take the additional evidence that they were adducing.
That is whether that can be done in the review application or not, that is what is to be
My
said.
lord, in the revision, the question is now, they are asking my lords to pass a direction to directing the lower court to accept the evidence, my lord, to the appellate court. That is what they say.
To accept
And also for allowing the adducing of additional evidence as has been prayed for.
not accepting, for allowing them to it.
My lord. So, my lord, the
When
moment.
only evidence is adduced, then only the question of accepting or rejecting will come,
My lord.
isn't it?
So, for that, we will have to go and see if the court below has exercised jurisdiction or not.
You are running very fast. You are not again confining to this thing. You see, the question, you are again now traveling to that question,
My lord.
whether their grant of prayer for additional evidence can be granted a review application or not.
My lord.
That is all right. But then that is second stage here, so far as this case is concerned.
My lord.
Maintainability is something else. See, maintainability is on the basis of the situation of the case, present case, and the basis of the situation which was before the apex court and the judgment. Now,
My
can we make a distinction of these two on the basis of plea of application of doctrine of subsilentia by Mr. Chakraborty? That is what you address the court on that. Whether doctrine of subsilentia will be applicable in the facts and situation of the case.
My lord, for it to be applicable, we will have to weigh both the sides. Now, when it is coming from them that the ratio is different, the facts were different, but my lord, the interpretation
You do not agree to that aspect that his case is basically not a case, or his appeal at this stage of not come under section 96. It will not be a first appeal. For him, that will be a second appeal.
My lord.
Now, do you have a dispute with regard to that?
My lord, it will be
Is
a
it not something that these are admitted situation, neither you can change, neither he can change?
My lord.
So you have to argue give that. Now, on that basis, can the doctrine of subsilencio be applicable?
My lord, for it to be applicable, we'll have to see, my lord, how am I also being aggrieved on it? If the decree is modified by the revisional court, will it take away my right for a subsequent appeal?
Do you want to say that the consideration of the fact whether it's a first appeal or second appeal, it is immaterial so far as the purpose of application of this proposition of law is
My lord,
concerned?
my lord, else the court would have travelled beyond the judgment to say that this is only applicable to 96 or to 100. But the court uses the word appeal. Court categorically states any decree which is appealable.
Can there be something more specific on doctrine of subsilencio?
My lord, I can look into it. Today I am armed with this particular
At least for
judgment.
the purpose of enlightening the court.
My lord.
You can educate the court on that.
My lord, today I am only armed with this judgment which I have
But
placed.
then it was only for the plea of maintainability. The court was expecting you to be there with that.
My lord.
Basically, that is the purpose when court wanted you to be here physically.
My lord. So, my lord, as far as my argument on maintainability goes, their petition is not maintainable because, my lord, the judgment does not differentiate. The Apex Court says it uses the word any decree which is appealable and in which a review has been rejected. The order rejecting the review shall not be taken up in a revision under 115. This is what the literal conclusion of the judgment is, my lord. Now, it's a question which my lord is posing that whether it will be applicable only to decrees and issues under 96 or to proceedings under 100.
See, application of doctrine of subsilencio is not dependent on the words used on the judgment.
My lord,
It is only a matter how do you distinguish the judgment, the application of this.
my lord,
Okay, now that is here. Now, you are repeatedly harping on that, what Apex Court has said in that judgment.
my lord.
There is no dispute with regard to that. And that is why basically this situation has come. How to distinguish this. Otherwise, there is no question of distinguishing this judgment.
My lord, para 42 in my basic understanding, my lord, for all the reasons above, among all the reason is also the reason where my right might get hampered. That is all. That is what they say,
If this is all the reason above, that will means what is contained in that judgment.
my lord. And the law
Nothing beyond that.
no, and the law discussed above, my lord.
It did not say for all the reserves
My lord.
of the universe, is it?
No, but there also is a reason which says that my right also should not be aggrieved.
No, just rather, we see, without going this way and that all, just can you just confine yourself with regard to the limited scope
My lord,
available to a court to apply doctrine of subsilency? In what situation it can be?
my lord, I'll be constrained to read 2 paragraphs for it. They're very short
You
paragraphs.
can read it. You see, you have a right to read it.
My
Read
lord.
it. Yes, read.
For all the reasons above, we are of the considered view that where an appealable decree has been passed in a suit, no revision would be entertained under section 115 CPC against an order rejecting on merits a review of that decree. The proper remedy for the party whose application for review of an appealable decree has been rejected on merits is to file an appeal against that decree. And if in the meantime the appeal is rendered barred by time, the time spent in diligently pursuing the review application can be condoned by the court to which the appeal is filed. In view of our conclusion above, the revision of the respondent against rejection of our application for review of an appealable decree ought not to have been entertained by the High Court. The appeal is therefore allowed, the impugned judgment and order of the High Court is set aside.
One question will remain, Mr. Chakraborty. Now, so far as application of order 43, rule 1W, the application of law in case when the grant of review or the review is granted. Now, say supposing if had there been the case, instead of rejecting, court had allowed your review, then in such a case you would have availed that order 43 rule 1W. Okay. Now, say supposing if this court now allows your application and grants you review, accordingly directs the trial court to reconsider the decree. Will it not that right, very right available to him will be taken away? Because that is what you say, otherwise it's okay, quite acceptable till the stage the judgment comes to that paragraph 43. That is where the problem is. Now, in such a case,
And Mr. Miller, what your
the
lordship?
proposition of the apex court has to be made universally applicable in case of matters where order against order appeal is available against a decree.
So on that order 43 million, then I'll try to.
That is what
Come.
see, like this is a purely question of law, because see normally it is not a duty of the revisional court to interfere with decree. That is why against final if you go by the general proposition of law, nowhere you will find that the scope of revision is available against final order. It is always or decree, rather decree. Now here it's a case, the fact remains that it is a decree. The order passed by the appellate court, the review of which you are seeking, it's a decree. So there cannot be a dispute. Now it is a decree, then appeal lies. And then again that paragraph. Anyway,
Miller, on
you
this
can make your argument, we can
on this query, Miller, which your lordship was
you will keep it reserved for we will pass order on. See?
on the subsilence, Miller, I have cited one judgment.
What is that?
Subsilence, Miller, the 1991 4 SCC.
Page
91 4 SCC, page 163, para 41. It is there.
Yes.
Page 163, para 41. No, 163 is the relevant part. Actual judgment starts earlier. 159, I think. 139. This is SCC 1991 4 SCC.
Citation complete.
State of UP. No, the page. Page 139.
There is 163 is the middle of the judgment, Mr. Chakraborty.
My lord, there's relevant part.
Give us first the citation, then you come to the relevant.
Oh, yeah, sorry. 139.
Pardon?
139.
139. Relevant even, page 163, para 41.
Yes. Para 41, yes.
Para 41. This para discusses the subsection. Does this principle extend and apply to a conclusion of law which was neither raised nor preceded by any consideration? In other words, can such conclusions be considered as declarations of law? Here again, the English courts and jurists have carved out an exception to the rule of precedence. It has been explained as rule of sub silentio. A decision passes sub silentio in the technical sense that has come to be attached to that phrase when the particular point of law involved in the decision is not perceived by the court or present in its mind. This is the definition given by Salmon in Salmon on Jurisprudence. In Lancaster Motor Company versus Bremit Limited, the court did not feel bound by earlier decision as it was rendered without any argument, without reference to the crucial words of the rule, and without any citation of the authority. It was approved by this court in Municipal Corporation of Delhi versus Gurnam Kaur. The bench held that precedent sub silentio and without argument are of no moment. The courts thus have taken recourse to this principle for relieving from injustice perpetrated by unjust precedents. A decision which is not express and is not founded on reasons, nor it proceeds on consideration of issue, cannot be deemed to be a law declared to have binding effect as is contemplated by Article 141. Uniformity and consistency are core of judicial discipline, but that which escapes in the judgment without any occasion is not ratio decidendi. In so and so, it was observed, it is tried to say that a decision is binding not because of its conclusions, but in regard to its ratio and principles laid down therein. Any declaration or conclusion arrived without application of mind
These are
or
all general principles.
general. This the doctrine of sub silentio. This is what the court found, Miller. And Miller, regarding that, what my friend was arguing on the concluding part, and that Miller, there is one. Where is that? What is the citation? Huh? Page. 1992 4 SCC, page 363. That is the citation, Miller.
That is regarding what? 1992 4 SCC.
4 SCC, 363. Commissioner of Income Tax versus Sun Engineering Works. Miller.
Yes, this is on what? In relation to what?
Miller, this regarding Miller, the ratio decision, Miller. If I can take, Miller, I'll just read it, one sentence, Miller.
Paragraph? Which page? Which paragraph?
Page, relevant page is
This
385.
income tax matter.
Yes, yes, Miller. 385 million.
Yes.
Millard, 385 para 39. Millard, fifth line from bottom, Millard. Fifth line from bottom.
It is neither desirable.
Yes, yes, Millard. It is neither desirable nor permissible to pick out a word or a sentence from the judgment of this court divorced from the context of the question under consideration and treat it to be complete law declared by this court. The judgment must be read as a whole, and observations from the judgment have to be considered in the light of the questions which were before this court. A decision of this court takes its color from the questions involved in the case in which it is rendered. This is the relevant part.
This is okay. These are known proposition. We have
Well
there is
settled.
no quarrel so far as this proposition of law.
Very well settled. Ratio is not the final finding.
There is no quarrel so far as this present case is concerned.
Well,
on
well.
those proposition of law.
Now, Millard, on this order 43, Millard, what your lordship is
No, that is
querying.
what what appears to be right now. You see, like if that also, if any passing of any order causes an interference with the statutory right granted to them, that is something.
So Miller, again, my friend has taken your lordship through the prayer. I'll take the prayer made in the petition, Miller. So I will just come back to that, Miller, on the prayer made in our petition.
No, see, prayer and all right now, so far as the issue of maintainability is concerned, I don't think that will be very much relevant.
Oh no, on the issue of mental. That is true, Miller. That is true.
That is the second limb of your argument. The so far as the
No, that aspect of Order 43, Rule 1, which your lordship had queried, Miller.
yes, one order 43 rule
1W?
1W.
1W, Miller.
Now this is
On that query, Miller,
yes.
the prayer which we have made here, Miller, in our petition, Miller, if I can take your lordship,
You just tell us. You do
Miller, what we have prayed, Miller, we are not asking, we are not praying before your lordship even to grant the review application. We are just praying before your lordship to resend the matter back to set aside that review order and resend the matter back to the review court for considering all aspects.
If you say setting aside that, then you have to show us that what is the jurisdictional error by the court.
Yes.
Now, your plea will be that your application for consideration of adducing additional evidence was not considered.
Right.
Now, that can be considered in a review application. That is what you have to show us.
That means the jurisdiction of the appellate court and the review jurisdiction, there is no distinction between the two. That is your lordship's basic query.
See, what you are trying to contend, it appears to this court, the irrespective of the fact of the pendency of the appeal or not, this jurisdiction exercised by the court would be an exercise of appellate jurisdiction.
Appellate jurisdiction, yes.
Now, probably, you see, like this court has some doubt about this thing because so long a review is not granted, your appeal remains dormant because it is decided.
Appeal itself.
Appeal remains dormant. It is so far as the decree.
Appeal
by the
itself.
appellate
Yes,
court.
agreed, Miller.
Okay.
Agreed.
It gets.
But when it comes to
gets
jurisdiction,
revived,
Miller-
it gets revived when you are granted review.
The appeal is revived. Appeal itself. Yes.
So if appeal is not revived, whether court can exercise power under Order 41, Rule 27.
Because, Miller,
Now you have to give something on
the
that.
jurisdiction remains the same, in my submission. Jurisdiction of the court, Miller, when it is exercising a review jurisdiction,
That is where you just give us something. Otherwise, you see, like can see like your prayer basically could come only after the appeal was revived. If appeal got revived, then only we could have made this prayer for reducing fresh. But then otherwise, no.
and
What's the
my
question of making this application in a dead case?
so Miller, what I'm saying is that, Miller, when the review jurisdiction is invoked,
Review is irrespective, it is available almost before all the courts. Until and unless it is barred specifically. Okay, because even the apex court also has the power of review. High Court also has the power of review.
Miller. So, Miller, the jurisdiction of the honorable court, Miller, is the same. Miller, here, of course, in this judgment which my friend has cited, Miller, in this judgment there is some discussions on the fact that the revisional jurisdiction which is exercised is basically a part of the appellate jurisdiction. It did not talk about the review jurisdiction, but the revisional court, Miller, revisional court is also exercising its revisional jurisdiction not as a separate jurisdiction but as an appellate court itself. This has been discussed in this my friend's judgment only.
Yes, revision is basically narrower, appeal is wider. Okay,
But the jurisdiction is the same.
jurisdiction is the same. See, like in the revision, the court basically doesn't remain with the facts. It is mostly on the the manner of jurisdiction exercised by the court which passed the impugn order. That is what it is. Appellate jurisdiction is wider jurisdiction.
So, Millard, what this in this judgment it has been discussed, Millard, in a particular place, which I was not relying on, Millard, is that the jurisdiction is the same. Revisional court, when the revisional jurisdiction is exercised, that is also within the.
That is only a part of appeal.
That means the jurisdiction itself is the same jurisdiction. So, Millard, in that same line, whether I can get something on review
You
jurisdiction.
see, in review, your fact basically, no, you get it. That is better. If you get it, definitely that will enlighten the court also. Mr. Khera also do some more research and can do more research on that. But then, you see, Mr. Chakrabarti, so far as the exercise of revisional jurisdiction appellate is concerned, perhaps the understanding of this court is that the appeal is basically wider. The ground which you can take in a revisional jurisdiction.
Powers are wider.
Powers are wider.
But the jurisdiction
area
is
of
the same.
consideration. Okay. Now, jurisdiction is something like a level. You see, like if you come to the, you see, the difference is that in review, you are confined to the question of law touching the jurisdiction of the court. In appeal, it is much more wider. Beyond that, it can take this plus other ground. So that is why maintainability of revision.
that
Revision
means
is basically supervisory power.
what your lord, my lord, but we will try to get
Probably we are getting mixed up. You see, like the argument is not confined to the question of maintainability first and coming to these things. Now here we have to consider both the things together.
So, shall I take your lordship through this prayer which was?
Yes.
Well, your lordship is now. Your lordship is reserving the.
No, but then if you want that you should be given some more opportunity to giving something, we can do. We are not against it. But then if you conclude, we will reserve it. There is a.
On that order 43 rule 1, Millard, if we can.
That is, there are two aspects of the thing, and second thing is that whether the court, while considering the review application, can exercise appellate jurisdiction or not. That is the main thing. Could have exercised appellate jurisdiction. The review purpose is totally different. The question of, you see, like giving you an opportunity to adduce evidence in a review application,
Whether that's possible or not.
not very appealing to this court. Because the court understanding, you see,
If I can satisfy your lordship that when exercising the powers of review, here, Millard, I distinguish between power and jurisdiction. I distinguish between power and jurisdiction. Millard, what I would submit before your lordship, that the powers may be different, but the jurisdiction is the same. So on that, Millard, if I can
review
get
remains
something.
review. You exercise a review jurisdiction.
Powers of Millard, here I am distinguishing. I am distinguishing a little between powers and.
No, you see, the review exercise can be exercised by a trial court. of its
Yes,
own
yes.
order, review
Whatever
court,
is the original
an
jurisdiction,
appellate court, even a high court, even Supreme Court.
or original jurisdiction, whatever it is, Millard.
So review as such cannot be categorized as appellate jurisdiction or original jurisdiction. Review is review jurisdiction.
No,
it, has,
but-
it has its own identity, own self.
What your lordship is querying basically, what I am trying to distinguish, Millard, is that powers are different, but jurisdiction is the same. On that, if I can get something.
Just let us not make anything. See, anything complicated. Just simple understanding of the court. This court understands. Then when an appeal is disposed of and it is decreed, this appeal is dead so far as that court is concerned, the court which passes. Now when you file review application, so long this review is not granted, the appeal remains in dormant status. It doesn't get revived.
No, appeal itself.
Yes.
Appeal itself.
So whether if in a dormant appeal, whether order 41 rule 27 will be applicable or not. We will not make things complicated, unnecessary.
Millard, your lordship will grant me a short time, Millard, not a very long time. Because it has to remain, because the matter has been substantially argued. And
Yes,
your
yes,
lordship is very conversant with the facts of the case also. So Millard, only on this point, if I can get something.
These are the question of purely question of law. The facts is not much thing. Yours is appeal, first appeal, section 96, your plea is based on section 96. His case is with case law, basically, yours is 100, section 100, second appeal, and the case law which he has furnished, basically it concerns section 96, the appellate. So the apex court, according to your apex court determination in that case, is solely on the basis of that first appeal, the party's right of availing first appeal, not second appeal. That is what your plea is.
My lord,
Okay, we'll keep it perfect.
my lord, will request for only 2 days time, my lord, because I don't want the matter
No,
to
no, you
escape.
see, Mr. Chakravarti, whether we can do it or
No,
not,
no,
because the
after the
problem
summer-
is that
After the summer vacation, my lord. I am also.
that is, it will remain perfect. We'll go after these things.
First week of June.
That is what. You'll be here, isn't it? You'll
No, I'll
be-
be here, I'll be here.
That is what you do it. And if, in the meanwhile, if you can get some more specific decisions.
Right.
These are general proposition, Mr. Chakravarti. There is no
Dispute.
quarrel. And Mr. Khera also has not basically raised any plea on that, those propositions.
But the certain issues and questions as framed by the court will also endeavor to come up with
We
the.
do not know. See, the court, today what is there in the court's mind, tomorrow it may not be there. The court also forgets. Okay, but then once we are involved with the question of law,
My lord.
the,
My lord.
whichever way the mind is.
I think the review, revision, and appeal.
But then
how they-
primarily two things remains: the exercise of appellate jurisdiction in a review application by the appellate court,
My lord.
or rather powers of in Chakravarti's language, power of appellate court.
We'll come. We'll
Will not say jurisdiction. We'll
Power.
say okay.
we'll come up if we can.
Okay. The hard learned counsel of the parties. Stop this case. Hearing could not be concluded. At least after 2 weeks.
My lord, in the meantime, my lord, there is one interim protection given to us, my lord, let me continue. Because the execution has been
Is
filed.
there any interim order? Ask.
We are
In
not,
the case,
my lord, we are not pursuing anything. It is there. There is no question of me pursuing. If I do that, I'll take the oath of the court. So, my lord.
Counsel is there with you, so you do not have any fear.
Obliged.
Item number 2.
Obliged, my lord.
Obliged.
May it please, Your Lordship. I am extremely sorry, Your Lordship.
Yes, why you are sorry?
I was unable to give a mention during the mentioning. The reason for that is
Doesn't make it the thing. You argue the matter. Court is happy. You may be sorry, but then court is happy that you have not mentioned.
Your Honor, the reason is that I received a late instructions and that I am stuck with traffic, and as of now I have nothing to.
See, traffic
Bring
and
to the
all
court.
cannot be a reason for adjourning things. Just tell us, yes, what do you want now?
I prayed for 1 week time, Your Lordship.
This is service matter.
No, my lord, not much, my lord. The boundary dispute, my lord.
2016, the boundary has any interim order.
There is no interim order.
Then it remains like this. What is there to pursue? 10 years.
My understanding is this matter
The
has become infectious.
parties by now will be happy with the situation which they have. Any effort to alter it will cause difficulty to them. Is it not?
Yes, sir.
Probably the council here is very serious. He is not.
According to my understanding, my lord, this matter has become infractuous. Boundary has been erected. And erected not by the order of this honorable court, my lord. They have challenged the order of the CEM. CEM order has been complied with by the district council. They have come before this honorable court in 2016. And they have not pressed, my lord, and it's still pending. Now, my lord, what has been done cannot be undone, my lord.
See, like a situation has been settled. It should not be unsettled right now.
Yes, exactly.
Because of the period of time, 10 years now.
The wrong will become right because of the lapse of time.
Not exactly that, my lord.
Okay, there is no question of adjourning it for 1 week. It will not serve any purpose. It will go after 2 weeks. Just prayer made on behalf. Are you an advocate on record? You are making a prayer on behalf of whom?
Senior JM, thank you. My senior JM, thank you.
Okay, on request made on behalf of James. He never comes. You see, like he is a man who is not there. You see, we do not know, and these are old cases that become burden for the court. Until and unless you parties cooperate, we cannot dispose it.
Yes, Your Lordship.
On prayer of the Plaintiff on behalf of Mr. Janthi, Lord of Counsel appearing with the petitioner.
Highly obliged, Your Lordship.
By the prayer of the respondent, list of 2 weeks. Yes.
Item number 3.
Item number 3, I'm again praying for some time, my lords. In fact, I had informed my friend also.
I have no objection.
This is also a matter where you said that there was some compromise,
No,
something
the
like that. and all.
settlement did not work out. Did not work out. We can hear the matter, my lord, after the holidays.
After the holidays.
Prayer made by Learned G, not opposed by the Learned Counsel for the petitioner, list after 2 weeks. Yes.
Obliged, my lord.
All right, my lords.
Item number 4.
May I please, Your Lordship?
Yes.
Lordship, in this case, the petitioner filed his application for restoration of a writ petition, 81 of 2019, to its original file. The matter was dismissed for default for non-prosecution. On that day, counsel who usually appeared before this honorable court, unable to appear. Therefore, this honorable court was pleased to, if I directly take your honor to page number, annexure number 3, page number 13 of my petition. This is the order where this honorable court was pleased to dismiss the case for non-prosecution. An earlier one occasion also, if your lordship peruse annexure number 2, on that day.
Yes, it was dismissed twice.
Yeah, twice. And on 2 occasions, the counsel failed to appear. And on annexure number 1 is the 5/6/2025, the earlier order, where the counsel was represented, but the counsel appearing on the opposite party prayed for some time. The honorable court allowed, and we also say that we no objection on that prayer. So thereafter, subsequently on 2 occasions, the
See,
counsel.
first 5/6/2025.
Yes, annexure number 1 is 5/6/2025.
Yeah,
When
the government asked for time.
yes, they prayed for some time, and we made no objection on that. Thereafter, the matter was fixed on 26/2025. On that day, the council was not present. And thereafter, the final order on annexure number 3, where the lordship was pleased to dismiss.
Yes.
I have stated the grounds of the why actually the state council could not appear. From para number 6.
Yes, Mr. Sen, any objection against the?
And to be very honest, I originally didn't intend to have any objection because it is premised on the council's demise of the council's father. But my lords, we'll just see para 7. I just read it a while back in detail. Page 5, para 7.
Yes.
So the premise is that the council's father had expired. Please see that the petitioner begs to state that a few months ago the father of the engaged counsel, namely so-and-so, expired due to cardiac arrest. And then she also says the mother is unwell. Now, she's not the only counsel, there are several other counsels, but please look at the death certificate at page 15. In case it is not legible, Lordships may see the typed copy on the next page. The date of death is 29/10/2024.
Okay.
Perhaps there's not been much application of mind here.
No, definitely I look into the matter. Actually, what happened, my lord, she is the practicing, at the time she was the practicing lawyer of Guwahati, and she is the native place is Tezpur. It's around 200 kilometers away from Guwahati. And after the demise of her father, she used to stay with her mother because the health of the mother also deteriorated. And the council, there is another council, Mr. Vijayalakshmi Ghosh. She is a local representative of Council of Meghalaya. And her father also expired, my lord, after some time.
No, but then you see, like where
my
you say,
submission-
see, you can the paragraph see paragraph statement. What statement you made?
Lordship. My submission before Lordship is that in the writ petition, my lord, opposite party already submitted their objection. We filed our rejoinder also. Matter was fixed for final hearing for a considerable time. And the matter, Lordship may kindly dispose of the matter on merit. This is my humble prayer because only for the reason for the councils only, the matter was disposed of. Only 2 occasions they failed to appear before this. Otherwise,
She says that her the council's mother, the father expired few months back.
Few months back, the date of filing of this application is 2nd of December 2025. If you actually look at the date of death, it's
no, I am not saying that immediately.
In few months it has become 1 year. So that is the only thing.
I'll leave it up to Lordship.
It
I
is not
just wanted to
utterly
point that to you,
misleading.
Lordship. Because even after that date, she's appeared on several, about 5 days thereafter. 5 days thereafter.
Lordly council. This is Miss number 297. Your name, please.
P.P. Borthakur.
To people to Lordly council appearing for. Applicant. Have you filed any objection, Mr. Sen?
Yes, to this we have. I'm not really, I just wanted to point this to you, Lordships. Just to examine the sufficiency of the cause. That is all.
So let it be.
Lordship.
And also Mr. Sen, Lordly council appearing for. You're appearing for all the respondents?
Lordship.
Appearing for all the. Appearing for the state respondents. Paragraph. This is an application for the restoration of WPC number 81 of 2019, which was dismissed for default of 10 default on 10/7/2025 on the ground of for default, yes, for default. Stop. The Learned Counsel appearing for the petitioner and drawing attention of this court. You can sit down, sir. Drawing attention to this court to the developments made in the application. Submitted that the dismissal of the writ petition was not because of the fault of the petitioner, but for the reasons of difficulty faced by the counsels representing the writ petitioners. Counsel representing the writ petitioners. He submits that the submits that the learned counsel was representing the petitioner had lost her mother, her father, and thereafter her old aging mother also had some health issues. He submits the due to the above reasons. The writ petition could not be proceeded with diligence, which resulted in its dismissal. We submit that since there was no intentional default on the part of the petitioner, the writ petition may be restored back to file. So that the same can be decided on merits. Mr. Shen, learned GA, appearing paragraph after paragraph, and Mr. Shen, learned GA, appearing for the state respondent, has submitted that the reason cited in the application seeking restoration is not supported by proper evidence. And in that view, comma, the genuinity of such reason remains a question.
And my lord, I'm so sorry. This is one more point I forgot. If you shall just look at the affidavit. I'm so sorry. Kindly just see this, my lord. Page 9 of the miss case that they filed for restoration.
That is miscase 297.
Yes.
Yes.
The restoration application.
Yes.
In my mind, this affidavit is also very defective. Please see, it has been signed by the association. Association cannot be a party to an affidavit. And compare this with the affidavit in the writ petition. my lord. Page 9 of the miss case. Affidavit has been signed by an artificial entity in the name of the artificial entity.
President.
President has signed it, but please see the first line. Vasu is swearing the affidavit. Please compare this with the writ petition, their own affidavit in the writ petition. Completely defective. They should not have passed the registry in the first place.
Voluntary decision for
Yes. This is an artificial entity.
You withdraw, file a fresh application. This is the problem. See your affidavit.
And their own affidavit in the writ petition, my lord, that is correctly done.
The way you have done it.
Yes, Lordship.
See, even verification also is saying.
Yes, Lordship.
Voluntary decision for also. You see, it has to be something like that. Someone has to
Yes.
represent. So it has to be like that. Just you withdraw it, we will give you liberty to file a fresh. Okay. There appears. Just कर दो जितना लिखा है सब just cancel it. Just say hard land counsel for the parties. This will be in miscase 297, na? Then full stop. There appears to be certain mistake in the affidavit appended to the instant miscellaneous application. The learned counsel for the appellant 6 permission to withdraw the same with liberty to file afresh. Stop. The prayer has not been opposed by the learned GA paying for the respondents. Stop. Accordingly, this application stand dismissed on withdrawal with liberty as prayed for. Wait first. Please be careful with this.
Lordship, I apologize. I should have said it at the very outset.
Exactly.
I apologize.
The court must have at least dictated.
No, I apologize, my lord. I apologize.
Or maybe he did not like the way order was going.
No, that's.
Nothing more.
Like,